Good morning. We have three cases on this morning's calendar, and we'll take them in the order in which they appear. The first case is DOUCETTE versus NEUTRON Holdings.
Good morning.
May I ask if counsel is present for the appellee?
Please,
Oh, counsel
You're
is
on,
on.
Ryan.
I see. Thank you.
and begin your honor.
Yes.
Good morning, Your Honor. May it please the court, opposing counsel. Your Honor, this is a case about an arbitration agreement in which the appellant in this matter is asking this court to vacate the arbitration agreement because of the unconsciousness of that and the egregiousness of this agreement. This was a case where she rented the electrical scooter from the appellant by way of an app. And the brakes failed on it. She yelled out, "My brakes don't work." She crossed over a street, ran into a cyclist, ended up falling, breaking her leg. She filed this action in December of 2020. And the parties came in, the appellant came in and filed a motion to compel arbitration. Because Ms. Doucette opposed that, the judge ruled that granted their motion to appeal, and we filed an appeal in this matter. Now, our basic argument in this, Your Honor, is that the arbitration agreement is so unconscionable and so egregious that it should be void. And we base that on the provisions that they have in the contract. And when we look at the contract, we look at the remedy that's involved in this. This
Can I ask
contract,
for a second, because you said two different things, and I just want to zero in on it. At one point, you said that you think the arbitration agreement was unconscionable, and now you're talking about kind of the provisions of the contract as a whole. Is it your position that we shouldn't be looking just at the part of the contract as a whole that is focused on arbitration, where it says, okay, the parties agree to arbitrate, and here are the terms of the arbitration, and I mean, following the JAMS rules and all that, to determine unconscionability, but rather if the contract otherwise, in terms of what liability is established under the contract and all that kind of the substantive components of the contract, have terms that you think might be problematic, you think we should be considering those as well?
yes, I do, Your Honor.
And why do you think that?
Well, because the terms of the contract provides that the appellant in this situation waives everything. There's no remedy for the appellant. When you look at the contract, it says, okay, you hereby waive any rights to hold line or any other person responsible for any act, whether we are negligent or not.
But do you have authority for saying that these arguments, in fact, affect the arbitration agreement?
Well, they're in the arbitration agreement. We don't have any authority to say that these are unconscionable, but if the court can look at that itself and say it's unconscionable. When we get a
Could the arbitrator look at it and say these substantive provisions are unconscionable?
I'm sorry, did the arbitrator?
Could the arbitrator look at it and say those things?
No, we didn't make it to the arbitration.
Why can't I know you didn't, but
Okay.
if it went to arbitration, could the arbitrator say, well, you're right, these provisions are unconscionable, so I'm not going to enforce them?
Well, the arbitrator can look at it, but again, that in itself is unconscionable, because if we allow the arbitrator to look at it, this is a binding arbitration. There's no appeal whatsoever. And of course,
But
DC code.
that's where you're, I'm not quite sure I'm following your argument. If there's an agreement to have an arbitrator decide things that is focused on that aspect of it is reasonable, and arbitration is lawful, and so there's nothing intrinsically suspect about an agreement to arbitrate. In fact, our cases say that arbitration is favored. Why is it problematic? Let's say then the underlying agreement is terrible and incredibly unfair. Well, it seems as though if there is what seems like a fair and valid agreement to have the rest of the dispute sorted out in arbitration, that's a point that's available, but it's one that needs to be made in arbitration rather than in the court.
Well, yeah, and even if we accept that, but if you have an arbitration agreement that from the get-go to say, okay, you have to do this within 1 year. Well, Miss Doucette was laid up for over a year. She broke a leg. She was house-ridden for over a year. So by the time she even got to a point where she might started the process, she lost out because they say within 1 year you have to notify them in writing the whole bit.
So just to make sure, are you saying that kind of, at least there is the fact that it's a contract of adhesion, which I think is undisputed. It's not like there was an ability to negotiate these terms. There's an ability to forego the service, but not to negotiate the terms. So you have that as relating to unconscionability, even with respect to the arbitration agreements. Now, you said also that you think to the extent the arbitration agreement required initiation of arbitration within a year, that is somehow so unbalanced or unfair as to contribute to unconscionability. Is that the point you're making now?
Yes, Your Honor. Yes, exactly. Because if the person doesn't do so in a year, then they lose out. And you know, that circumvents the DC law, DC 12301, that said, okay, you have 3 years to bring action for negligence. But based on this arbitration agreement, it circumvents that, saying, okay, if you don't get this started in 1 year, then you're pretty much going to lose out. You had a year to do so. We tried to resolve it, and if you can't resolve it.
I mean, I see why it is not entirely in the interest of a potential claimant to have to bring a claim within a year. But do you have authority to support the idea that that kind of a time frame is so short as to contribute to a conclusion of unconscionability?
Well, Your Honor, I don't have any authority, but I look at DC code that the legislators decided, okay, we'll give 3 years for negligence action. And if you're going to circumvent that in an arbitration agreement, say, okay, the term wasn't you no longer have 3 years, but the terms were you need to do something within 1 year. And I think that in itself is unconscionable. And
Well, I suppose it may or may not be, but if you were to go before a judge instead of an arbitrator, the judge, the 1 year issue would still be before the judge, right? The judge would have to decide whether that's unconscionable or not.
I agree, they would.
Okay, whereas if you go before an arbitrator, the arbitrator would decide whether it's unconscionable or not, right?
Yes, but if the arbitrator, I'm sorry.
Well, what I'm wondering is why you think it's okay for a judge to decide it, but it's unconscionable for an arbitrator to decide it.
Well, because if an arbitrator decided and rules against us, then that's the end of it, because it's about.
If a judge decided and rules against you, that's the end of it.
Well, we have the Court of Appeals. We can come to the Court of Appeals and ask the Court of Appeals to review this.
But this is an argument that all arbitration is unfair because of the reason you just given, which is that the arbitrator's decision is de facto final unless you can meet some very strict requirements for overturning it. But we know for a fact that that's not a grounds for objecting to arbitration.
No, the main grounds for objecting to arbitration, Your Honor, is the egregiousness of this contract. It's quite egregious.
But we're making a distinction, you see. We're asking you if you have case law that answers this question. We're making a distinction between the unconscionability of the requirement to go to arbitration to resolve the various issues and the unconscionability of some of the substantive terms of the agreement. And our thinking is, shouldn't the issue before us only be whether this agreement to arbitrate is itself unconscionable? Is there something unfair about, something unconscionably unfair about letting the arbitrator rather than the court decide this?
Well, yeah, my argument would be, yes, it would be unfair to let the arbitrator decide it, because again, if the arbitrator decides,
These arbitrators, you know, are often former judges of the Court of Appeals and other courts.
Yeah, I understand, but we had a judge who looked at it and decided just the opposite as well. The judge said, well, I thought the procedure portion of it was good. You know, I thought it was fair, but he did not touch on the egregiousness of the unconscionability of it. He did not touch on the adhesion of the contract.
Well, I thought the trial court did here determine, I think contrary, over the objection of your opponent, the trial court determined that the issue of unconscionability was for it. And it decided that matter unfavorably to you. And in doing that, it listed, you know, it kind of went through the agreement and said it's a neutral arbitrator and neither side has a unilateral ability to pick an arbitrator and it doesn't impose asymmetrical, you know, obligations and the like. So, I mean, the trial court has decided that at least the arbitration component of this agreement was not unconscionable. And I have a question about that, which is, assuming that's what the trial court did, is it your view that our review of that conclusion is de novo, or do you acknowledge that our review of that should be in some way deferential to the ruling of the trial court?
Yeah, I think it was the de novo, and if I'm not mistaken, unless the court made a mistake, the court said he did find that it was conscionable. I'm court indulgence. Let me find that. I think the court did. And I'm having trouble finding, but I think the court did say that he found it to be unconscionable, but apparently he never touched any further on that. He thought it was fair as far as procedure analysis.
And by it, you mean
The court's language.
the contract, though, is on, the court said the contract is unconscionable.
The court said, let's see one time.
But I'm just looking at the transcript of the trial court's oral ruling. I think it's at page 14 of the transcript on that date. It might be 169 of the joint appendix where the trial court says, I find that the contract here, although an adhesion contract, is not unconscionable. I therefore, you know, grant the motion to compel arbitration.
Okay, and thank you, Your Honor. That was the language. He did find that it was a contract of adhesion, but he didn't find it was unconscionable. We argued that it is is a contract of adhesion as well as being unconscionable. And I think if the court would have took a closer look or a close analysis of the terms of the contract, it would have found that this contract is just so egregious that it had to be overturned. And I cite the Bennett case with respect to that says that you could have either procedure defect or unconscionability, and if it's egregious, only one is required. They said it's just a two-pronged test, but if it's that egregious, then all you need is one.
And part of your argument, I think, has continued to be that in assessing unconscionability for this purpose, the trial court was required, and we are also required to look at the contract as a whole, including provisions that don't directly relate to arbitration. And I understand that, but assume for a moment that we really need to look only as the trial court really. Other than the statute of limitations that would apply under the DC code. And then the third is that arbitration, if you go that route, you lose the ability of kind of direct judicial review of it. You don't get a ruling from a trial court, and you don't get direct judicial review by an appellate court of the trial court's ruling. So I have those 3 points. Is there anything else, if you're zeroed in really on the agreement as it relates to arbitration, is there anything else about the agreement that you would rely on to argue that it's unconscionable?
Well, the mere fact that I think the only other thing that I would do, you have a 36-page arbitration agreement. You have a person who goes up to it and have a phone app. And of course, if you try to read it on your phone, it's going to be more than 36 pages. It probably have somewhere around 120 pages to flip through to read just to ride this fight. And that in itself, I think is unreasonable. It's the procedure portion of it that there is a contract. I mean, but how many people will actually go through and read an app of more than 120 pages on a cell phone to figure out what's going on with it?
Can you remind me, I guess I have 2 questions about that. One is, can you remind me whether your client alleged as a matter of fact that she was unaware that the agreement included an agreement to arbitrate?
Yes, she was unaware.
Well, my question is not whether she was or wasn't. I was just wondering whether she alleges that in the record. Like, is that part of the complaint or part of the argument that she was claiming that?
I'm not certain if we made that a part of the argument that she was unaware of the arbitration agreement. But as most people, when they go to rent these bikes, they just basically use an app, they charge it and they go.
And the other half of my question, I guess, is my recollection is that the part of the trial court's unconscionability ruling was to say that the agreement to arbitrate component of the overall contract was like early on and very prominent. Do you disagree? Do you dispute those aspects of the trial court's analysis?
No, I don't dispute those aspects of the analysis, Your Honor. But I think if the court, you know, and I keep harping on the adhesiveness of the contract and unconscionability of the contract, because, you know, this is a situation where it just deprives the general public of a situation. If the Court of Appeals or if the city council allows people who rent services just to go in and say, okay, these are the terms, you're going to waive everything against us. You have no right, no recourse from us. And if we are liable to anything, it's no more than $100. I mean, that would violate, you know, the spirit of, you know, democracy, the spirit of public policy to say, look, you can't win. Not only do you waive your right to come after us and hold us accountable, but any other party to this or that may or may not be. And that is unconscionable. And I think that's in the procedure portion of it. That would be a total unconscionable situation in that. And I think the court needs to invalidate this contract based on that.
Okay. We'll give you a few minutes for rebuttal. Let us hear from your adversary now.
Thank you, Your Honor.
Mr.
Thank you.
Go ahead.
Apologies. John Nader for Neutron Holdings, the appellee, DBA Lime. Your Honor, thank you for your time. This court must affirm the Superior Court's October 25th, 2021 order granting Lime's motion to compel, because it complies with the precedent of this court, holding that arbitration agreements within a consumer contract of adhesion are enforceable, provided that they are not procedurally or substantively unconscionable. The Superior Court reached that conclusion after briefing and after holding a hearing, and Ms. Doucette offers no compelling reason to deviate from it. For the reasons stated in our brief and in a few moments, Your Honor, we submit that it must be affirmed. There's really no factual dispute here, Your Honor. Ms. Doucette rented a scooter. She registered with the Lime app using, which provides a consumer the opportunity to register either with a phone number or a Facebook account. In that process, a consumer is presented with hyperlinks that they can then click on to read the specific terms of service, in this case, or privacy policies. Those are conspicuous. They're on the face of sort of the initial splash page of the app. And they're readily available. The Superior Court, in finding that agreement was enforceable, sided with two other federal district courts in which the same agreement, the same Lyme agreement, was also found to be enforceable.
May I ask you, do you think that the issue before us is whether the substantive provisions, limitations, and so forth in the agreement are unconscionable, or only whether the portion of the agreement that requires any dispute to be arbitrated is unconscionable?
Your Honor, I think the proper analysis should focus on the arbitration agreement. The Supreme Court of the United States in Buckeye check cashing with respect to our agreements under the Federal Arbitration Act, which this is subject to, provides that an arbitration agreement is severable from the underlying agreement that it is a part of. So the Supreme Court said, as a matter of federal substantive law, an arbitration provision is severable from the remainder of the contract. I think the Superior Court examined the arbitration agreement rather than any other sort of extraneous agreements with respect to the use of the vehicle, sort of other unrelated terms of services, unrelated to arbitration. So in answer to your question, we're looking at the arbitration agreement, which is a subset of the larger user agreement, and the analysis the Superior Court underwent properly focused on that with respect to procedural and substantive unconscionability. Again, the issues on appeal are limited. Was the Superior Court correct in finding that the arbitration agreement was neither procedurally and substantively unconscionable after it held a hearing on Lyme's motion? And we submit it was, Your Honor. The court focused on three cases from this court: Keaton, Andrews, and Woodruff, which I submit Ms. Doucette did not substantively address. As you know, Your Honor, in the District of Columbia and elsewhere, arbitration agreements are valid, enforceable, and generally favored as a mechanism to resolve disputes, especially in the consumer merchant context. Under the DC Revised Uniform Arbitration Act and the FAA, arbitration agreements are enforceable provided there's no underlying legal or equitable defense to undermine the agreement, such as a minor, or in this case unconscionability, or any other sort of contractual defense. In this instance, the arbitration agreement also included a delegation clause, which provides that disputes concerning the arbitrability of a dispute or a claim are subject to the determination of an arbitrator. Those are, in that case, the reviewing court determines, was there an agreement to arbitrate? Are there equitable defenses to the same? But in this case, again, those issues with respect to the enforceability of the arbitration agreement itself are delegated to the arbitrator. Those are uniformly, again, subject to contractual defenses, uniformly enforced as a matter of federal law and DC law.
Counsel, I understand the trial court's decision to decide the unconscionability issue that it did decide was, I think, over your objection on the view that really under the provisions you're just describing, that too was for the arbitrator. And it sounds like maybe you're making that same point now. Are you, the trial court has ruled on that issue, however, favorably to you. Are you seeking, you're not seeking that we set that aside on the theory that really the trial court shouldn't have decided that and rather an arbitrator should have? Or are you?
We're not making that argument, Your Honor. Another point, the court determined it was a contract of adhesion. We don't necessarily agree with that, but I don't believe it affects the enforceability of the arbitration agreement. So no, we're not asking for reversal on grounds that the issue should be decided by the arbitrator. I believe the court, regardless of whether it properly decided the issue, we believe it was correct in that respect.
Does your position mean that if you prevail in the arbitration, Ms. Doucette could nonetheless take an appeal to this court seeking review of the trial judge's determination on unconscionability?
No, Your Honor. I mean, it's, again, I think that's the issue here.
You see, my point, the point of my question, I think, is something like this. If the issue of unconscionability is for the arbitrator, and the arbitrator makes a decision that it's not unconscionable, then Ms. Doucette's ability to challenge that by going to court and asking the court to vacate the arbitration award is very limited, as you know.
Correct.
But if the threshold decision on arbitrability is properly made by the trial judge, and the trial judge says, okay, I find it not unconscionable, go to arbitration. If that was a decision for the trial judge, then you would think that if the arbitrator then doesn't denies Ms. Doucette's claim, it would still be the appellant would still be able to appeal, not the arbitrator's ruling, but the trial court's threshold ruling. That's why I think this sort of matters a little bit.
I see your point, Your Honor. I suppose I'm trying to distinguish it from where we are now. We have, again, regardless of the propriety of the Superior Court's determination of whether the agreement was, whether he was sort of overstepping his authority or sort of stepping on the toes of the arbitrator in this regard, I believe I don't believe that it would undermine Ms. Doucette's rights under the arbitration agreement. I don't believe it would prejudice her at all. Again, she would ultimately receive a hearing on the merits of her claim. Whether she has a procedural argument to raise after the fact, I don't have an answer to that specific question, Your Honor.
But just to
I don't believe
you're not. You haven't argued that this interlocutory appeal is improper, or that notwithstanding that you're in the trial court, you thought the arbitrator should have decided the unconscionability question. The arbitrator should have decided the unconscionability question rather than the trial court. You haven't objected to our reviewing the merits of the trial court's ruling on that unconscionability issue in this appeal. Is that right?
That's correct, Your Honor. I believe we cited statute and Andrew's case from 2015, providing that the court can review an order authorizing an appeal from an order denying or granting a motion to compel arbitration. So no, Your Honor, our position is not that the court's without jurisdiction or can't hear the merits of the appeal.
And just to follow up with the question that I asked your opponent, what's your position about the standard of review that we should apply to the trial court's determination that the arbitration component of this agreement was not unconscionable? Should we be reviewing that de novo, as your colleague suggests, or do you think that the trial court's ruling on that topic is entitled to some sort of deference?
Your Honor, I would suggest that it is a deferential review, but at the same time, with respect to this, with respect to the issues here, I think you would reach the same conclusion. We're referring to contractual provisions that in most jurisdictions are questions of law for the court. So I believe there's little fact finding that the court would have to perform to determine whether the terms as written are unconscionable under the standards under the precedent of this court. Specifically including whether the parties were treated equally under the agreement, whether the absence of choice by Ms. Doucette, which the Superior Court concluded she had not met her burden of establishing that she could have obtained services elsewhere, again, these scooter bike services elsewhere, without having to engage in arbitration, and whether the terms were unreasonably favorable to Lime as compared to Ms. Doucette. I think the Superior Court, in your reading of the contract, would establish that both parties are treated equally. In fact, Ms. Doucette has probably more advantage in arbitration compared to litigating, given that she has the opportunity to prevail or secure attorney's fees if she prevails, where she would not otherwise under the American rule, under the nature of the complaint asserting negligence.
As you read the agreement, let's suppose hypothetically that in the arbitration, Ms. Doucette establishes that she was grievously injured and has huge damages, and her injury was attributable to some form of negligence on the part of Lime in making the scooter available to her. Does the agreement limit her damages that she can, the damage award that she can obtain from Lime?
I will, Your Honor, as my colleague pointed out, it is a lengthy agreement. It is 36 pages, but the arbitration agreement is more discreet. I will find an answer for you in the meantime, Your Honor, as I did not focus on that particular issue. But let's assume that it is let's assume it's $100 that caps Lime's liability in this instance. Again, there's freedom to contract. There's opportunity to, again, Ms. Doucette does not deny that she had the opportunity to review these terms. Otherwise, she wouldn't have been able to rent the scooter. So assuming at the moment, without pinpointing the site, that she has limited, her recovery is limited under the terms, she agreed to it. Similarly, she agreed.
Her recovery is limited under the terms of the agreement, and then I lost what you said.
Apologies. Assuming, Your Honor, it is limited. I just don't have I'm not.
So would you think that, my recollection is that agreements to limit liability for negligence are disfavored in the law. I may be wrong about that. This is not something I've looked at in a long time, but I have that recollection. Would it be unconscionable if the agreement says, look, Ms. Doucette, maybe Lime was terribly at fault here, and maybe Lime has caused you a grievous injury, but your damages are limited by our agreement to $100. And the court has said, well, I don't find that unconscionable, or the arbitrator said, I don't find that unconscionable, or they neglected the point, or whatever. That would not be something that could be raised on appeal in your view?
I think there's a distinction, and to your earlier point, there's a distinction between a limitation of liability and a sort of waiver of liability. Again, having looked at this issue recently in another jurisdiction, it's your point. You're correct that waiving your rights to sort of entirely to assert, sort of releasing a party from future negligence is generally disfavored. I think in Virginia, it's specifically unlawful. In this instance, we're talking about terms that are outside of the arbitration provision. If Ms. Doucette wanted to argue that the limitation of liability, which, Your Honor, it is $100. It's page 75 of the appendix, 7.2 and 7.3. If she wanted to argue that that clause was unconscionable as a matter of District of Columbia law, she could raise that issue in arbitration. And again, provided that there is some that argument, let's say she loses that argument, if there is a basis under the DC law to appeal that discrete ruling, she could do so. But again,
well, that's why I focused earlier on the question of whether unconscionability is for the judge or for the arbitrator. If it's for the arbitrator, I'm not sure. And the arbitrator says, well, $100, that's fine with me. It's not unconscionable. I'm not sure that Ms. Doucette can obtain judicial relief from that ruling. Because judicial review of arbitral rulings is so narrow. But if we posit that what we have here is a judicial ruling, that this agreement is not substantively unconscionable, and if that was appropriate for the judge to make that ruling, then it would seem as if it can be examined on appeal, is my thought. What do you think of that?
It's a good question, Your Honor. I think that the context in which a consumer can seek judicial review of an arbitrator's decision is limited. And again, not having the standard memorized, I recall that it is pretty egregious. It's usually a disregard of applicable law or facts, something that would essentially undermine the propriety of the arbitrator's conclusions. I don't find that, provided that the grounds under which a consumer can seek relief from the court of an arbitration agreement apply with respect to an argument as to the limitation of liability. Sure, I think hypothetically she could, a consumer could, but again, the sort of narrow, the space within which to assert those, to seek judicial review is rather limited. And again, not sort of in a vacuum, I can't say that it would apply in this instance. It depends on what the arbitrator does, I believe, sort of in examining that issue or reaching that conclusion. So the answer is possibly, Your Honor, depending on, again, how the arbitrator reaches that conclusion. But generally, no, Your Honor, with respect to the sort of universally, could she? No, under certain circumstances, possibly, depending on, again, whether the arbitrator was wholly without, the arbitrator's decision was wholly without basis or legal or factual basis.
Can I take you back to the to Judge McLeese's question about a standard of review? Whether or not you think this is how it should have gone, given that the trial court did address unconscionability. I think you said that there should be deferential review of the trial court's determination of unconscionability. And did you say because there are facts involved, basically the judge is going to be reviewing this contract in a specific factual context as opposed to on its face? And what are the facts that it's considering that would for us only be appropriate to consider on a clear error review, for example, as opposed to looking at the contract and saying, what do we think of this?
Well, yes, Your Honor. Well, in that regard, the Superior Court, Ms. Doucette's burden was, among other things, was established that she had no alternative or had very little alternative to seek the similar or same services elsewhere and avoid arbitration. The court found that she had not met her burden, that she had not established those facts. So had she sort of presented or demonstrated, for example, the limitless other e-bikes and e-scooter apps don't require binding arbitration, don't limit liability to the extent this agreement does. I think then you would have to, again, deference would be due the court in that regard, considering it sort of first heard the evidence. But that wasn't presented in this instance. This was more a fact. The facts here were essentially derived from the facts developed were derived from the terms of the contract, which is generally a question of law for the court to determine. So I think applying either standard, Your Honor, you reach the same conclusion that based on the terms, based on the record before the Superior Court, the absence of any facts that Ms. Doucette offered to meet her burden in opposing arbitration, coupled with the Superior Court's review of the terms of the arbitration agreement, were consistent with its obligations under this court's precedent, and it complied with the court. Well, it complied with the again with the Keaton, Andrews, and Woodruff rulings in finding that again there was no procedural unconscionability. So there was no substantive unconscionability based on the terms of the again how the parties were treated under the arbitration agreement itself, and that's what we're focused on.
Can I apologize for a kind of a left field question, but it relates to the court's jurisdiction. So I'm just curious if you have thoughts about it. I hadn't really focused enough, I think, on the fact that the arbitration agreement by its terms, as you pointed out, provides that the Federal Arbitration Act is what will govern, not this jurisdiction's RUAA, Revised Uniform Arbitration Act. And I wonder if that has any implications for our jurisdiction, because a number of the cases that treat orders compelling arbitration as immediately appealable rely on a provision of the DC RUAA that expressly says that they are interlocutorily appealable. It seems, but in trying to figure out whether this order is interlocutorily appealable, do you think we should be looking to that provision of the DC RUAA and concluding that it is? Or do you think we need to determine that as a matter of what the Federal Arbitration Act properly understood permits by way of interlocutory review? Or do you think that's more kind of a matter of a matter of the judicial forum? So I'm just curious what you think the relevant body of law is for us if we're trying to make sure we have jurisdiction over this interlocutory appeal to be considering in answering that question.
It's a good question, Your Honor. Again, the agreement provides for the arbitration for the FAA to apply. It also would apply as a matter of law, considering the parties are well, this is a matter involving interstate commerce. I will, Your Honor, get to your point under the FAA with respect to what jurisdiction or what grounds it can review agreements under that statute can be reviewed. Sorry, determinations of arbitrability can be reviewed under that statute, if you permit me for a second, Your Honor. Again, I can get you an answer to the question, Your Honor. I think my answer at the moment would be if you find that there are no grounds to review the act, or sorry, the order because of the applicability under the FAA. Again, it's not a point I have an answer to or a position to at the moment, but I would posit either under the DC statute or under the Arbitration Act, which again, I'll find an answer for you in a moment to whether it can be heard at this stage.
Mr. Nader, one final question for you from me, if I may. Do you read the trial judge's decision in this case as having decided the substantive unconscionability of the contract, or only the unconscionability or not of the arbitration requirement in the contract?
Your Honor, I would, and no apologies necessary for the questions, I appreciate them. I would, Your Honor, the Superior Court examined the arbitration agreement and its various terms, including whether, again, the treatment of the parties with respect to cost, selection of arbitrators, etc. So the answer to your question is it focused on the arbitration, properly focused on the arbitration agreement rather than the overall 36-page agreement, terms and services, which is consistent with, again, the law of the Supreme Court, the precedent from the Supreme Court providing that arbitration agreements within larger agreements are severable. Again, the Superior Court found that the agreement itself was a contract of adhesion, but this court has held that even so, arbitration agreements within contracts of adhesion are not per se unlawful or enforceable, provided they're not substantively or procedurally unconscionable. Your Honor, on one point on the FAA, 9 U.S.C. Section 16 pertaining to appeals, 9 U.S.C. 1 is the Federal Arbitration Act. Section 16 provides an appeal may be taken from an order denying a petition to arbitrate, denying an application to compel arbitration, confirming an award or partial award, or modifying or correcting a record. An appeal may be taken from an interlocutory order granting, continuing, or modifying an injunction against arbitration, and a final decision with respect to arbitration under the FAA. An appeal may not be taken from an interlocutory order granting a stay of an action, directing arbitration to proceed, compelling arbitration, or refusing to enjoin an arbitration. So my position would be that perhaps not under the FAA, but perhaps under DC, under the RUAA, the court can review this issue at this time, despite the pendency of the litigation. Your Honor, subject to any other questions, I thank you for your time. I'd ask you to affirm the Superior Court's order compelling arbitration. But again, subject to any questions you have, I appreciate your time.
Counsel, thank you. Mr. Graham, we'll give you a couple of minutes.
Thank you, Your Honor. Your Honor, I think the court was correct in saying that the arbitration agreement, the court only looked at the procedure aspect of this agreement. The court looked at that, the court found that fair, and the court basically laid out 4 points in saying that it was fair. The court said that basically both parties were bound by the arbitration. It said that the arbitration was neutral as respect to who would be conducting it. The court said that the cost would depend on the outcome and that both parties were treated the same. And procedurally, the court looked at that and it came to that. The court did not take into account the unconscionability and the adhesiveness of the contract. Counsel said, well, Ms. Witchcomb could win attorney fees. There's no way she can win attorney fees because in the contract, she waives everything. So there's no possibility of winning. There was 99.9% chance of losing.
I'm not sure why you say the trial court didn't take into account the fact that it was a contract of adhesion. I thought the trial court acknowledged that it was, but concluded that in virtue of these other considerations, on balance, the arbitration component of the agreement was not unconscionable.
Well, I think you're right. The court said it took into consideration, but I don't think the court looked at the full details of it, where everything was ruled against her with respect to the substantive terms of the agreement. She waives any right to come after Lime. She releases all damages to Lime, whether they're responsible or not. Lime even indicated in their contract agreement that even if we know that we had problems with this.
But were those arguments made to the judge, and why don't you think they were considered?
Well, they were made in writing to the judge. Yes, they were. We actually laid out those provisions that we put out in this brief, and I can't say why the court didn't take it into consideration.
Well, why do you even say the court didn't take it into consideration? What's your evidence of that? Just because it was the decision didn't say, here are the 20 things I considered, and if you made these arguments and they were sort of subsumed in the overall questions, why wouldn't you think he considered it?
Well, I guess I can assume he didn't consider it, but if he did, Your Honor, I think he would have gave it a second look.
So you mean he wasn't persuaded by it?
He wasn't persuaded by the fact that she can only get $100 if she wins, that she waives all her rights. She releases everybody from liability, Lime, including any of the contractors or anything that Lime might have. My position of that is that he could not have.
Well, I think that the logic of the trial court's ruling is those arguments may well be very persuasive ones, but the trial court didn't think it was time to decide them. I think the logic of the trial court's opinion seems to be, I have a narrower issue in front of me. Is it fair to send this dispute off to arbitration? And the trial court thought the answer to that question was look at the arbitration related provisions. And if some of the points you are making, and you made to the trial court and are making again in this court are correct, like the limitation, the substantive limitation on liability is unfair and the like. Those are points that in an agreement the trial court viewed as fair, your client agreed to have resolved by an arbitrator in the first instance rather than by a court. So, I mean, I think the logic of the court's argument, the determination would be those points are kind of premature and not the court's homework at the time. The trial judge thought the homework at the time was, is this a fair agreement to have all of the rest of those points resolved in the first instance by an arbitrator?
And that could have very well been the court position, Your Honor. But I think, again, if we look at it and we go to an arbitrator, then what recourse will Ms. Doucette have if the arbitration rules against her? It's considered a binding arbitration. The terms are egregious to me, and then there's no recourse. So I think the proper recourse, based on a URAA, is that, you know, the Court of Appeal, the court should look at that, and the Court of Appeal should look at what the trial court did in this situation. And that's what we focused on, Your Honor. And we find that that contract was one of adhesion. It was grossly egregious, and it should be invalidated. Thank you.
Counsel, thank you both.
Thank you.
The case is submitted.
Thank you.
And you may, Mr. Nader, you may log off.
Thank you, Your Honor.
We'll now call the second case on the calendar, Stevenson versus DC Water and Sewer Authority. Morning.
Good morning.
Morning.
I'd like to reserve 2 minutes, please. Good morning, may it please the court. This is an appeal from the trial court's grant of summary judgment and denial of a motion for reconsideration in a case that alleged 2 counts. 1 count was under the DC Human Rights Act for race discrimination and retaliation. The 2nd count was a wrongful discharge claim. It's our contention that the trial court erred in its decision in granting summary judgment and denying the motion for reconsideration because there were disputed facts for the race discrimination and retaliation claim, as well as the wrongful discharge claim. Concerning the hostile work environment race discrimination claim, the court determined that this claim could not proceed, even though some of the acts were beyond the 1-year statute of limitations. But the case law is clear that if there's 1 discriminatory act within the statutory period, then the court can consider other acts as part of a hostile work environment claim.
Why do you call your claim a hostile work environment claim? Was it characterized as that in the complaint?
It's race discrimination, and we did allege that he was subjected to a racially hostile work environment.
Where can you show me where in the complaint would I find that?
Your Honor, in the joint appendix at 13, we state that specifically DC Water and Spears, as the other defendants, suspended and terminated Mr. Stevenson based on his race and in retaliation for a complaint of discrimination against Gendry and attempting to report the threats in the workplace to the DC Council.
Right, and that specific allegation doesn't seem like a hostile work environment claim. That is, there were adverse employment actions, 2 specific ones that were taken allegedly on in a racially discriminatory manner.
And Your Honor, just continuing, the allegations against Stevenson were false. DC Water negligently investigated the allegations and then proceeded to terminate him. And DC Water had multiple reports of workplace violence made against plaintiffs. Workplace violence against plaintiff's supervisor. So, Your Honor, it doesn't specifically say a hostile work environment. I agree with that. But the allegations in the complaint was that over a period of time, he was subjected to threats of violence, assaults in the workplace. We've listed the incidents. He was eventually terminated in 2019, but these events commenced as early as 2016. In terms of the race discrimination claim,
Can I ask you, leaving aside the complaint for a minute, in opposing summary judgment, did you develop or use that concept to describe the nature of your claim, kind of hostile work environment? Was that part of your opposition to the motion?
it was part of the opposition to the motion for summary judgment. We did allege that events outside of this one-year statutory period could be considered as part of a hostile work environment claim. Your Honor, in terms of the race discrimination claim, Mr. Stevenson alleged that he was working in a racially hostile work environment where racial slurs were frequently used. He cited not only what happened to him, but how he was treated in comparison to his supervisor, who had multiple assault charges filed against him, and no action was taken against the supervisor, even though they were both reported to the same second level.
But this is one of the main issues, I think, is the extent to which he's similarly situated to his supervisor. It seems, first of all, is it right that you're down to one person now that you're saying is similarly situated? And how can he be similarly situated if, one is a supervisor or even his supervisor? The behavior takes place in, completely different periods of time. And one thing that seems pretty significant is the fact that Mr. Stevenson, when he came back from his period of suspension, then immediately, picked up more claims against him or allegations against him for the kind of conduct that he was disciplined for in the first place, which I don't think is true of Mr. Poland. I mean, is there case law that would push the concept of similarly situated this far?
Your Honor, in the context of discipline, when your employer has disciplinary policies that apply across the board, then the standard of similarly situated, I don't think that standard applies in that context. In terms of if you have, for example, if you have two employees who punch another employee in the mouth, one person happens to be a manager, one person happens to be an employee, and one is Black and one is white, and the Black employee is either the manager or the employee, and that person is terminated, but the Caucasian or white employee is not terminated. In that instance, the employer's policy, it can't be applied in a discriminatory manner. And that's essentially what his claim is. You've alleged that I've engaged in these assaults or threats in the workplace, when in fact, I am the person who's filed a complaint of threats against my supervisors, but my white male supervisor has verified claims made against him of threatening and fighting and punching and engaging in other acts of violence. But I don't have these same type of allegations. He gets.
Yeah, but one of the ways
excused.
that we decide whether it was discriminatory is looking at whether it is true to say that the exact same thing happened to these two people and one of them was fired and one of them wasn't. So it's still relevant to look at, if Mr. Stevenson was fired, after he came back from a suspension, the question whether that had anything to do with race turns to some extent on what happened, what the situation with the white employee.
So, Your Honor, in terms of what happened when he returned from the suspension, his allegation or his contention is he came back from the suspension. He was being assigned back to this place back to the office that he had filed a complaint against because he thought he was threatening that office. He spoke to the union representative and he asked, basically, why aren't you challenging the fact that I'm being put back into this environment that I filed a complaint on? And There was some disagreement with the union. The union, according to Mr. Stevenson, the union said, you have an attorney, take it up with your attorney. And then then the union representative filed a complaint that Mr. Stevenson terminated, that Mr. Stevenson threatened him. Something that Mr. Stevenson is disputed. He says it never happened. So basically DC Water suspends him, he returns, and then the union has to know that if there's a charge or a complaint made that he will somehow threaten someone, that he would be terminated. And he's terminated after the union steward makes a statement that he somehow felt threatened by this conversation with Mr. Stevenson. But
So,
it
Mr.
still
Branch-
boils
Mr.
down
Branch,
to
getting back to the question of the supervisor as a comparator, your opponent relies on the following quote, or really two quotes from a decision of ours called Collins, that says an employee is considered similarly situated to the plaintiff for purposes of showing disparate treatment when all of the relevant aspects of the plaintiff's employment situation are nearly identical to those of the other employee. And then it goes on, the similarity, then the quote starts up again, must exist in all relevant aspects of their respective employment circumstances, which would surely include both their rank in the company and the alleged misconduct. Do you dispute that that's a correct description of the degree of similarity that is required? And if you don't, do you think you can meet it? Do you think you can show that Mr. Poland and your client were nearly identical in all relevant aspects, including rank?
Your Honor, they were not. Mr. Poland was Mr. Stevenson's supervisor. So of course they would not be at the same place in rank. They did report to the same second level supervisor. I think that's Mr. Regis, and that was considered. And I'm not sure that the authority that's cited by DC Water is the latest, just the latest statement of the law in this particular area. I understand that the EEOC has a more relaxed standard in terms of considering discipline and whether someone is similarly situated. But that's just one factor, whether the person is similarly situated. Of course, unless someone is in a position and it's actually his coworker who's in the same position, the same grade, the same title with the same duties. I mean, according to that, what you just read, that would suggest that that's the only person you would be similarly situated to. But in terms of discipline, where when your employer has a policy that says that we don't tolerate violence in the workplace, but here you're imposing a certain type of discipline on one employee who's African-American and a Caucasian employee who commits the same alleged, well, it's not even alleged, documented offense, more serious offense over a number of years, and that person receives much less discipline than Mr. Stevenson, who was suspended for 30 days and then was terminated.
Could you clarify something for me? I understand DC Water to be arguing that with regard to the disparate treatment of Mr. Poland, you're relying on materials that you obtained in another lawsuit, completely unrelated to this one, that were under seal, and that these materials were not submitted to the trial judge in this case or before the court when it was considering the motion for summary judgment. Do I understand? And in effect, they're arguing that we should not consider these materials either because they were under seal and presented late and so forth. Do I understand that correctly?
Your Honor, I think that may be their argument, but that's not accurate. Some of the documents that are involved in this case were involved in another lawsuit. But in that particular lawsuit, the individual who made the complaint filed an EEOC complaint, filed an internal complaint, and the documents were received as part of that process. I mean, I'm just representing that.
Were they under seal?
No, they were never under seal. And these documents were presented, DC Water received them.
Superior Court in this case on the motion for summary judgment?
Were they submitted to the Superior Court in this case on the motion for summary judgment? Yes. They were submitted as part of our opposition to the motion for summary judgment.
All of them?
I'm sorry?
All of them?
Yes.
Yeah.
In terms of the wrongful discharge claim, the court is clearly just incorrect on this wrongful discharge claim. DC Water argues that an employee that such as Mr. Stevenson is a public employee, when in fact DC Water is an independent authority of the District of Columbia. DC Water, there are many cases in this court where we've litigated cases in this court where DC Water, where there are claims against DC Water, the employee has no obligation, in OEA, the Office of Employee Appeals, doesn't even have jurisdiction
Counsel,
over termination cases under the.
I want to just zero in on something you did and make sure I'm following the jump. You said the trial court was plainly wrong in its ruling on wrongful termination, and then you started discussing one of the arguments your opponent is making. We go back to what the trial court ruled? What's your understanding of why the trial court denied your client's wrongful termination claim?
Your Honor, my understanding is that the trial court essentially adopted the argument made by DC Water. One, we allege that the wrongful termination claim should proceed. One, because there was an assault. The claim is basically there was an assault, as well as that there was an underlying claim under the DC Human Rights Act. That's dealt with separately under the DC Human Rights retaliation claim, which you can have.
Well, and I'm focused, I don't know if you have it in front of you or, but I'm focused on Joint Appendix 355, page 11 of the trial court's ruling. And the trial court at the top of that, I mean, the discussion of wrongful termination starts the preceding page, and it sort of, the trial court is saying what the arguments of the parties are. But then I didn't really see a ruling by the trial court saying, accepting your opponent's argument that this claim was precluded because your client was not an at-will employee. The trial court says that your client was not an at-will employee, and then says it's undisputed. And then cites a case, and what the defendant's arguments are about that. But I never said the trial court actually rule on that. What the trial court then goes on in the next paragraph to do, which seemed like the ruling to me, was to say that to focus on how you had responded to the summary judgment motion, to characterize that as saying your wrongful termination claim was entirely wrapped up in, this is my paraphrase, but entirely wrapped up in your DCHRA, wrongful discrimination / retaliation claim, to say then that isn't really what the complaint seemed like. You're not really allowed to amend your complaint by way of your opposition, but then also to say in any event, to the extent your claim, your wrongful termination claim rests entirely on your DCHRA claim, that the claim is therefore precluded, the common law tort claim is precluded because your remedy is under the DCHRA, citing this case McManus. And then going on to say also, because the trial court also found that those DCHRA claims lack merit, your wrongful termination claim, that's on the next page, 356, because your DCHRA claims lack merit, your wrongful termination claim also wouldn't survive. So that's what I had understood the trial court's ruling to be. Do you disagree with that understanding of the trial court's ruling? And if so, why?
I saw that in the trial court's ruling, Your Honor, but I think the trial court misapprehended the fact that we never abandoned this claim that, setting aside the DC Human Rights Act violation, we believe that my client, Mr. Stevenson, was terminated in part because he complained about an assault in the workplace, and it's well established in the DC law that falls within the exception of at-will employment under the DC. I think the case is Adams v. George Cochran and Company. The court makes it clear that a claim for assault, if you're alleging that you were terminated because of the assault, I don't know where the court is going. Where is it in your opposition?
You never, you say you didn't abandon it, but the trial court thought you had, sort of recharacterized it impermissibly and then ruled on it as you had recharacterized it, I guess. But I'm focused now on your opposition to the motion for summary judgment. This is a joint appendix of 221 to 222, where what is said, you mentioned that your allegation had been a wrongful termination claim based on a report of assault and violence. So you definitely say that had been was in the complaint, and you say the defendants latch onto that, but the defendant's argument is misplaced. And then you say your case is built on a violation of the DCHRA You clearly established, this is a quote now, that the successful prosecution of the claim of wrongful termination required proof of the underlying claim of discrimination and retaliation. And then and that's part of a quote from Robinson. And plaintiff correctly filed suit for violations of his rights under the DCHRA that resulted in him being fired illegally, and the related claim of wrongful termination flows therefrom. So I guess I'm not quite convinced yet that the trial court misunderstood the position you took in opposing summary judgment when the trial court said, whatever the complaint, and this is my paraphrase, but whatever the complaint originally was alleging, in opposing summary judgment, you tied this claim explicitly solely to the DCHRA claim. And the trial court said, if that's your claim, it fails for the two reasons the trial court identified.
Well, Your Honor, we had already litigated the issue on a motion to dismiss on whether this claim of assault, that I was terminated because I filed a complaint of assault, and the trial court denied defendant's motion for summary judgment specifically, motion to dismiss specifically because under DC law, if you allege that I was terminated, you were terminated because you filed a charge of assault or you allege some type of criminal activity, then that states a claim for wrongful termination. I agree that it's inartfully crafted here, but we've never abandoned our claim that Mr. Stevenson was terminated in part because he reported criminal activity.
Well, can I ask you how this issue was teed up in your brief in this court? So if you go to your opening brief in this court and the discussion of wrongful termination, this is on pages 30 to 31, it's essentially verbatim of, virtually verbatim of what was in your opposition to the motion for summary judgment. And instead of saying kind of some of what you're saying today, which is, look, the trial court didn't understand my claim. My claim wasn't really tied up. My wrongful termination claim was not tied up in the DCHRA claim. It was distinct. It was about reporting of workplace violence and the like, and assault. Instead, what's said here is the same things involved a violation of DCHRA, that you would establish that in order to prosecute your wrongful termination claim, you would have to prove your underlying claim of discrimination and retaliation. So the issue got teed up for us the same way it did to the trial court, as far as I can tell, at least in the opening brief.
I was looking at the reply, so.
I see that the reply, I think, focused on the other issue that was floating around, but I didn't understand to be the basis for the trial court's ruling, which was the set of questions about whether DC WASA employees have a remedy in front of OEA and are required to do that, and CMPA preemption, and also maybe the extent to which the tort of wrongful termination applies to employees who are not at will. So those issues you touched on in the reply brief, but this idea that the trial court in granting summary judgment on the wrongful termination claim, the trial court misunderstood your claim, thought it was tied up in the DCHRA, and missed the fact that the complaint originally had alleged something different. I just didn't see it in this court, in the briefing in this court.
So, Your Honor, just to wrap up here, it's plaintiff's position that the trial court erred in granting summary judgment and denying the motion for reconsideration on the disparate treatment, the hostile work environment, and the retaliation component of the case. I haven't really touched on retaliation, but plaintiff specifically said, I filed a complaint of harassment in early 2019. My complaint was under investigation. I then made a complaint to the general manager of DC Water when he did this road show, or basically a listening session. And following my complaint, first it was interrupted, and then secondly, I was suspended the following day. Then for 30 days, when I returned to work, I was terminated.
But can I ask what evidence did you present that the complaints you raised to management, kind of gave them notice that this was a racial discrimination claim?
So the complaint, first, there's no requirement. He did allege that I'm working in a hostile work environment. I'm being threatened in the workplace. The complaints were under investigation at the time that he was terminated. There is no requirement that he use the magic word, any type of magic word, but he's alleging that he was subjected to a hostile work environment. He reported this to the human resources manager. And this is the same person who interrupted him while he was trying to present additional information to the general manager, and the same person who ultimately terminated his employment.
Are you, and I guess Judge McLeese asked you some of these questions, that hearing the arguments put so much in terms of hostile work environment seems inconsistent with sort of my view of what this case was about when I was reading the briefs. Is this a sort of intentional shift of theory, or you're saying this has always been there and it just didn't come across?
Well, Your Honor, it was addressed in part by the trial court. He's always alleged that over a period of time leading up to my termination, I was working in an environment where there were threats, racial slurs were made. For example, even this allegation of using the N-word against him by the manager. So that's always been an underlying point here.
And I take your point that you wouldn't necessarily have to use any particular magic words, but could you concretely point us to any evidence where your client raised a complaint to the employer before discharge, or suspension or discharge, if those are the two adverse employment actions at issue, that was in any way racial, that whatever words you want to refer to, that had a racial component rather than terms that don't necessarily, like harassment or assault or violence? Is there anything in the record that indicates that your client communicated to the employer there's a problem here that relates to discrimination or race, rather than that there's a problem here that relates to violence and hazing and abusive conduct and the like, but not tied to race? So is there anything tying into race in any way through any word, magic or otherwise?
Okay. Your Honor, I know that in response to we stated all of the allegations that he made against coworkers of being abusive and threatening and pointing at his head with the fingers and mimicking a weapon against his head. And he specifically denied that he ever used the N-word to describe his supervisor. That was communicated to DC Water, because that's one of the reasons they said, we're terminating you because your supervisor said you use the N-word in referring to me. So he disputed that raises, that's a racial component to that point.
If I understand that, is he said to his employer, someone said I used the N-word, I didn't. I'm not sure that's a complaint. I mean, I guess maybe you could think of it as indirectly suggesting that someone is in fact discriminating against me on the basis of race, rather than unfairly accusing me of having used an inappropriate racially charged term. But that seems a bit of a leap.
Thank you.
Okay, let us hear from counsel for DC Water, and we'll give you a minute or two in rebuttal.
Good morning, may it please the court. The District of Columbia Water and Sewer Authority and George Spears, the defendants and appellees in this, are asking for affirmation of the order granting summary judgment. The court did not err in fact or law in issuing its order of summary judgment, and it did not error when it issued its motion of order, confirming that in its motion on the motion for reconsideration. There are 3 claims at issue here. None of them are hostile work environment. The claims are race discrimination and retaliation, which were kind of, we argued them separately, but in response were sort of argued together. And then the wrongful termination for public policy. The District of Columbia, or the DC Water, submitted 87 facts of not in dispute with supporting record evidence for every single one of those. In response, in the opposition, they were not opposed. Instead, what was submitted was what Mr. Stevenson claimed to be disputed facts. They did not address our specific facts.
Do you concede that Mr. Stevenson has disputed or did dispute during this litigation a lot of the key allegations, like the one with Mr. Jingori? Is that how you would say it? I mean, or do you think that the problem is this was just his own allegations? There's something in your brief that says self-serving, but why isn't that a way of creating a dispute if he's the person who would know what happened?
Well, what I would say is that Mr. Stevenson filed a document saying that there were disputed facts. I would argue that there were no actual disputed facts, because when you look at the documentary evidence in support of his what he alleges to be undisputed facts, what he's relying on is a declaration from Mr. Stevenson, whereas our statement of facts, we're relying on his deposition testimony. And the documents regarding Mr. Poland. And Judge Glickman, just to clarify for you, those documents were produced during a prior litigation under a protective order. So they were marked confidential, produced in that litigation. The protective order stated that they could only be used in that litigation. They were supposed to be either destroyed or sent back to counsel at the end of that litigation. Now,
is the declaration of Mr. Stevenson not allowed, or you're just saying it's not? I mean, relying on deposition.
I would say that it's not persuasive, because his declaration, if you look at his declaration, all it is repeating the allegations from his complaint. There's no, I mean, just because he says it happened, you have to have record evidence supporting that. And there's no record evidence.
His deposition record evidence supporting what his declaration record evidence supporting what he asserts in it.
Well, if you compare what we quote in his deposition and our statement of facts to his declaration, there's actually not any dispute.
Well, that's a different topic, I guess.
Right.
But part of your answer seemed to be that you think his declaration was in form in some way not capable of creating a material dispute of fact because it wasn't his deposition testimony or it was self-serving. And then there's also kind of the procedural point that it wasn't then referred to in a document that corresponded number by number. I get that procedural thought, but do you disagree that one way a defendant can create a material dispute of fact is by signing a sworn declaration that says here are some facts? Or do you think that's just not the right way to do it somehow?
I don't dispute that can be done. I dispute that that's what was done here.
And what was missing from that as it related to you're saying that if we look through that, there's nothing in there that was sworn by him in the declaration that is inconsistent with what your client was alleging were undisputed facts? That's
correct, Your Honor. I think his declaration, for the most part, just
for the most part is a little bit
Sorry,
different from
I will say that the vast majority of his declaration is copied and pasted from his complaint, and it's just allegations.
If he's sworn, that's where I'm confused again.
Go ahead.
If he has said some things about the real world and he swears to them in a declaration, they're not just allegations in the sense that an unverified complaint is. They are, in the form of sort of like they're no different from a deposition in the extent to which they could be relied upon in determining whether or not summary judgment was warranted or not. Or again, do you think otherwise? Well,
I think my point is that there's nothing in his declaration that disputes the facts that the District of Columbia or DC Water put on as their record evidence. There's nothing disputing that he engaged in conduct that led to his suspension and then to his termination. He makes allegations or statements with, his point of view on it, but he never says he didn't say the things that he was ultimately suspended and terminated for.
So his declaration doesn't deny his having used the N-word in the dispute with the other supervisor.
I believe it does deny that, but that was not the basis. That specific statement was not the basis for his suspension. The basis for his suspension was.
That may be right, but it seems if that was listed by your client as an undisputed fact, and if in a sworn declaration, Mr. Stevenson said that did not happen, then that seems like, leaving aside for a minute the form of the filing, the opposition and whether it's numbered to correspond with the alleged undisputed facts, that seems as though it is a material dispute of fact and substance.
Well, I would argue that that particular statement in the context of all of the rest of the evidence is not material. There were.
Well, had you characterized it as a material fact? Had your client characterized it as a material fact in connection with the motion for summary judgment?
I don't believe that we put, I'll have to double check our statement of material facts, but I don't believe we made the definitive statement that statement was made. I think what we put on there is a statement of material fact not in dispute, is that there was an incident with his supervisor of which was fully investigated. And we put the evidence of the investigation on the record, and that as the result of the investigation, it was determined that there was inappropriate conduct to justify his suspension.
So are you saying what's important is sort of the allegations and that he's not disagreeing that there were allegations? And is that sort of what this is coming down to, as opposed to the fact in the world? And is that what's important?
Well, I mean, again, this is a DC Human Rights Race Discrimination Act. So, the burden is to show that there was a prima facie case of discrimination, which we argue was not even met. But even so, that, once the action was taken, there's no evidence that there was pretext, that there was fully supportive evidence on both of the adverse actions that were at effect here, the suspension and the termination.
I hear Mr. Branch arguing now, at least, that his client, Mr. Stevenson, was treated differently for the alleged misconduct from the way his former supervisor, Mr. Poland, was treated. And Mr. Stevenson is African-American, Mr. Poland is white. Put aside the question of whether Mr. Poland is an apt comparator.
Mm-hmm.
Just put that question aside for a moment. Was the trial judge at the time of summary judgment presented with this argument by Mr. Branch that Mr. Stevenson is being treated materially differently from a white person who committed similar misconduct?
So in his opposition, Mr. Stevenson attached the documents regarding Mr. Poland. So there's evidence on the record regarding Mr. Poland. We again argue that evidence is inadmissible, but setting that part aside, there is evidence that Mr. Poland 10 plus years ago, prior to Mr. Stevenson even starting at DC Water, had issues. If you look at that evidence also shows that he was suspended for that conduct. So, I would argue at least is the underlying conduct. And
well, you're getting beyond, we'll get to that, but you're getting beyond the question I asked. I want to know whether and how this issue was teed up for the trial judge and how the trial judge addressed it on summary judgment.
As far as Mr. Stevenson's argument?
Yeah, in other words, Mr. Stevens is saying, look, you want a prima facie case of discrimination?
Mhm.
Here's my prima facie case. They charged me with some wrongdoing. Well, they also charged Mr. Poland with the same kind of wrongdoing. He's white, I'm black. Me, they fire. Mr. Poland, they, keep him on as a supervisor.
So I would say,
Now I'm simplifying a little bit to get to the point, but
I understand.
my point is, was that argument at summary judgment teed up? And I recognize your point that Mr. Branch did not handle the summary judgment pleadings well. He did not follow the rules, but let's get beyond that too for a moment and just get to the substance of this if we could. Was that argument teed up to the trial judge? And how did the trial judge handle it if it was teed up?
Yes, I would say that argument to the extent that the argument that Mr. Poland was treated differently the argument was made that he is a comparator and was treated differently. That's what was argued on opposition. In our reply brief, we argued, in addition to the fact that we argued that is inadmissible evidence, that not only was he not a comparator, but that he wasn't treated differently because the initial conduct, they were both suspended for fairly similar issues. When Mr. Poland came back, never had any further issues with him, versus Mr. Stevenson, when he came back, engaged in the exact same conduct again, and therefore that led to his termination. And I do think that the trial court did address that.
How did the trial court address that?
I apologize.
How did the trial court address that?
The trial court said, look at their order. I believe that the trial court primarily based the order on the fact that Mr. Stevenson and Mr. Poland were not comparators, which I think is the correct ruling. And then he also notes that so the trial judge does acknowledge that the argument was made. He ruled that Mr. Poland and Mr. Stevenson were not similarly situated, and that even if Mr. Stevenson had made a prima facie case of discrimination, that he then failed to show that there was any pretext for discrimination. That's my understanding of his order. And then he goes on to say that the undisputed facts of the case show that Mr. Stevenson consistently engaged in inappropriate, disruptive, and threatening conduct that resulted in his suspension and termination.
So did the trial judge take into, did Mr. Stevenson argue to the trial judge that there is evidence here from which a jury could find that those people are lying about me, in effect, and that I'm the one who was complaining and I was being about, the way I was being treated in various ways that Mr. Branch talked about earlier?
I don't believe that that's actually what the opposition to the summary judgment said. The summary judgment focused solely on the fact that Mr. Poland was a comparator and that they were treated differently.
Okay.
Unless you have any question on discrimination, I'll move to the retaliation claim. I think this is pretty basic. Mr. Stevenson admitted in his deposition that while he made various complaints, he never once tied it to any sort of protected characteristic, particularly race here. The case law in this court, particularly Ukwanami versus DC, has been pretty clear that if you're going to make a retaliation argument based on the District of Columbia Human Rights Act, that you do need to, during the course of your complaints, make sure that you are at least some way tying it to some sort of protected characteristic, which was not done here. There's also, in the opposition to the summary judgment, there was really no analysis of what the purported protected activity was, how that tied to the adverse action, to the extent that it was complaints made to human resources. Those were, I believe, 4 months prior to the suspension and 7 months prior to the termination. Both of those are longer than the typical causal connection that the court looks at to assume that based on timing alone that there was retaliation. So I think that even though there wasn't a lot of analysis on the retaliation piece in the order, that was properly granted on summary judgment as well. And then I'll just quickly address the wrongful termination. It's a little difficult sort of to follow the arguments. There's been shifting arguments by Mr. Stevenson in this and his complaint. He argues that it was the wrongful termination was based on reporting assault. The District of Columbia Water and Sewer Authority filed a partial motion to dismiss on this claim. That was denied based on the fact that in his opposition, Mr. Stevenson clarified that he was reporting criminal assault and relying on DC code 22/404. That code is never cited again in any of the opposition to summary judgment or the appeal before this court. He then goes on to argue, as the bench pointed out, that he's relying on the District of Columbia Human Rights Act, in which the court properly noted that's not proper for a wrongful termination of public policy argument. But setting all of that aside, sort of doesn't really matter why he thinks he was wrongfully terminated based on public policy. It doesn't apply because he was not an at-will employee.
Well, leave aside that for a minute. One of the arguments you had made in your brief was that DC WASA is covered by the CMPA, and therefore the CMPA would preclude any such common law wrongful termination tort. Your opponent cites in the reply brief a OEA determination that says otherwise, and I think our court may have some law on that topic as well. So do you continue to take that position, or do you agree that that argument was not correct?
I would agree that based on the current case law, that the OEA does not have jurisdiction over that particular claim. But I would also say that it doesn't really matter here because he was covered by a collective bargaining agreement and therefore was not an at-will employee. And because
Can you, I know that the trial court said he was not an at-will employee and you've alleged it, and it seems undisputed that there was a collective bargaining agreement. I didn't see the collective bargaining agreement in the materials available to us. I don't know if it was part of the trial court record. I haven't seen it yet. But you just said that you think because he was covered by a collective bargaining agreement, he wasn't an at-will employee. Do you think that is that necessarily so, or only typically so?
I think that's always the case. I mean, every collective bargaining agreement I've ever seen has a just cause provision, which means you can only be terminated for just
again,
cause.
practically, I tend to think that's probably true practically, but is it intrinsically true that it has to be, it wouldn't be a valid collective bargaining agreement unless it provided tenure assurances beyond at-will employment?
I don't know of any incidents where that's not the case.
Right, but my question is different, which is, do you know whether the law requires that or whether it doesn't tend to happen, but in theory it could?
I don't know whether the law requires it. I would imagine that there's not a union out there that wouldn't argue that it should be part of the collective bargaining agreement, and I've never seen one that doesn't include that.
In support of the idea that the common law tort doesn't extend to employees who are not at will, I think you cited an unpublished DC Circuit or a non-presidential DC Circuit opinion. Are you aware of law in this court that directly addresses that question?
I'm not. I think it's a novel issue, Your Honor. I mean, it's not something that we found any case law on one way or the other. And I think it's just probably something that's not necessarily litigated much because that would come up in the context of arbitration under a collective bargaining agreement in most cases. And unless you have any other questions for me, I thank you for your time.
Thank you. Mr. Branch, we'll give you a couple of minutes.
Yes, thank you, Your Honor. And I would just like to clarify for the court, I believe the court had a question concerning whether any of the documents in the prior case involving Mr. Poland were filed under seal. I didn't understand completely that the court was inquiring whether they were actually filed produced in some manner under seal or filed as part of a protective order in the prior litigation. There was information that was exchanged in that previous case before the case actually was submitted in court. Some of the documents were reproduced as part of that litigation, and at some point a confidential stamp was attached to some of the documents, maybe even all of the documents here. But some of this information was produced as part of the investigation of the prior claimant's claim against DC Water. So I just wanted to make sure I didn't misrepresent to the court that something was not filed under seal, if in fact it was filed as part of summary judgment motion and somehow placed under seal. I didn't recall that. Just wanted to clarify that. In terms of the allegations that Mr. Stevenson made, he began employment in 2016. The allegation against Mr. Poland continued at least through 2015. So there's not a 10-year difference. It's just, and the decision makers are the same. And for Mr. Poland, it wasn't just a single incident. There were multiple employees who complained that he either assaulted them or threatened them or whatever, all these events. And these decision makers were the same. DC Water senior officials in this department decided that Mr. Poland would get a slap on the wrist or, a minor penalty, but Mr. Stevenson was actually immediately suspended. Mr. Poland, I don't believe, ever filed any type of complaint against his supervisor, but Mr. Stevenson filed a complaint against his supervisor with HR, and then he's suspended for 30 days, and then he's terminated. So I just wanted to clarify those 2 points. And the other issue is the temporal issue, the time period between when he complained and the actions taken against him. I believe defense counsel represented that there was a 7-month period from the time he made the complaint and these actions taken against him. I think she said 4 months and 7 months. In fact, he made a complaint in January 2019 and a complaint in February 2019. He was suspended in February 2019 and then terminated when he returned from the suspension, or eventually terminated 2019. Had the exchange with the steward from the union, placed on administrative leave, and then terminated. So there is these events happen on top of each other, one behind each other. So that in terms of the temporal issue, that's not an issue here. It satisfies any concern about that. With that, appellant submits.
Counsel, thank you both. Case is submitted.
Yeah.
Do you want to take a break at all? Do you want to take a break at all? What? Do you want to take a break at all? We'll call the third case on the calendar. Case has a very lengthy name, which I'm not going to repeat in full. I trust you'll let me refer to it simply as the Ethiopian Orthodox Church versus HABTE et al.
Good morning, Your Honors. Let me start with my easiest point. If this court agrees with me that Dr. Amari Kasei was the church's alika.
Excuse me 1 second. I'm going to ask you to identify yourself for the record. Would you please identify yourself for the record?
Sorry, Your Honor, George Lyon. If you agree with me that Dr. Amari Kasei was the church's alika, that is the administrator of the church, when the appellee's purported board voted in 2016 to dismiss this action, then this case must go back to the trial court because that vote was invalid. Dr. Kasei was an ex officio member of the board. He was entitled to notice and an opportunity to participate in that meeting, assuming it was otherwise valid.
I've thought about this question, and I have I guess this. First, you said when the board voted to dismiss in, I think you said 2016. I think actually that vote was in January 2017. Am I not correct?
That may well be the case. I don't think the difference in dates is relevant, but
Maybe
I stand
not,
corrected.
maybe not, but I wanted to be sure of our facts here. The thought that has occurred to me is that Dr. Cassay and the other plaintiffs, I understand, tell me if I'm mistaken, are suing here in the name of the church.
Correct.
They are suing in their capacity as board members bringing a cause of action belonging to the church.
Correct, Your Honor.
Now, if they lack standing to do that, then I'm not sure Dr. Cassay's claim or any claim that the true board did something they shouldn't have done because I'm not sure that claim is properly before us. It sounds to me like that claim would be a derivative claim that would have to be brought basically, as a derivative action, which hasn't been done here. You see what I'm saying?
I do, Your Honor. When this case was filed, it was filed in 2015 because the appellees and persons associated with them had essentially excluded the board from being able to govern the church. Basically, they had locked out Dr. Cassay, they had locked out the board, they had prohibited persons who were loyal to the board from even entering the church. And so when the case was filed, it was filed in 2015 by the board in the name of the church.
And then what we have is a putative board decision in January 2017. That the church is not going to pursue this litigation and the motion to dismiss it. And what we have is, and that raises the question of whether Dr. Cassay and the other members, the others of your clients, to put it civilly,
Yes,
have standing to bring this action in the name of the church. And I understand, it's my understanding, correct me if you think I'm wrong, that they have the burden of proving that they have standing. And it sounds like, are you with me so far?
yes,
Okay, and it sounds like the question of their standing turns on the legitimacy of the 2015, the March 2015 and the March 2016 board decisions, or to put it another way, it turns on the legitimacy of the October 2016 election of the we'll call it the new board, and that in turn seems to turn on the validity of those prior board elections.
well, I think that the logic there is correct, although I would go further and say that at this point, there is a stale record because we don't know the legitimacy of any board elections following that. And that's another reason why this case needs to go back down to supplement the record. But if I could go back to the question.
Well, if they haven't been challenged, they're presumptively liable, but neither side has relied on any decisions made by subsequent boards, subsequently elected boards.
I understand that I understand that that's true, but I think realistically, we're at the point in 2022 where there is no evidence in the record of what is a valid board. If I could go back to the question of,
Right, but my point is it doesn't matter, it would seem, because the issue is simply whether the January 2017 decision to dismiss this action was a valid decision or not.
Okay, and it could not be because Dr. Kasey, as an ex officio board member, was denied notice and the opportunity to participate. The appellees did not even recognize him as the ALICA because they took the position that he was dismissed at this gathering that occurred in September of 2015, where Mr. HABTE took out of his pocket a list of people that he, on no authority whatsoever, appointed to be the interim committee to run the church. So there was never a valid termination of Dr. Kasey as the ALICA, and as the ALICA and as an ex officio board member, he had the right to participate in any board meeting to dismiss this case or any other
When
board meeting.
does the record indicate, does the record reveal when the new board, as I'll call it, the board elected in October 2016, when that board appointed, I don't have the name in front of me, Dr. Kasey's successor?
I do not believe that there is any evidence in the record with respect to that. My understanding is that it was the interim committee that made such an appointment. And of course, as appellees who testified conceded, that interim committee was not an official organ of the church and had no authority to do anything.
It sounds like the new board in some sense ratified the decision.
That may be the case, but there is nothing in the record to indicate that, to my knowledge. And again, Dr. Kasey had the right to participate as a board member in any such decision and was not afforded that opportunity, either notice or the opportunity to participate, as well as the 4 board members who had been elected in 2015 and were, for lack of a better term, purportedly terminated in that 2015 gathering by Mr. HABTE.
Can I go back? I'm not sure I got a clear answer to the question that Judge Clickman was raising about your point. I'll try to be a little louder. It sounds like you might be having trouble hearing me. Your point was, you started off by saying, well, here's an easy one. There's they made a mistake about who the right ALECA is. And if that's a mistake, then that will invalidate what happened in late 2016 or January 2017 at the end. And Judge Glickman raised a concern, which was, if that's the only problem, then it's unclear whether this case is properly teed up for that to be the claim that's being raised by the entities that are here in the form that they've raised their claim. And I just want to see whether you agree with that or don't agree with that. And I think the theory, I guess, is that if your claims otherwise fail, then it was permissible in late 2016 or 2017 to hold an election because there were some vacancies that weren't filled by the 2014, 2015 elections. And the board that was constituted as a result of that election made a vote at some point to dismiss this action. And if that was incorrect, if the only problem about that was that someone was not given proper notice of a particular meeting, that might not be something that could be raised on behalf of the church. That might have to be raised individually. I just want to make sure I understand. Do you disagree with that? And if so, why?
I do disagree with that, but not only because Dr. Kasey was denied the opportunity to participate, but also the 4 board members who
No,
were elected.
of course, I understand that you have other challenges to the 2014, 2015 election. I get that. I just wanted, I thought your point originally was, look, even if I lose all those issues, there's still this problem with the mistake about who the proper Oleco was.
The claim, Your Honor, is that the proper board has been denied the opportunity to govern the church. And that would, and as of 2016, 2017, that would include the 4 members who were elected in 2015 and Dr. Kassé. We also, the church conducted an election in 2014. Conducted an election in 2016 as well. And it's our position that there were no vacancies to be filled in that October 2016 election conducted by appellees. I would also note that we have essentially an admission from the appellees that they did not conduct that 2016 election in accordance with the bylaws, because they did not enforce the provision in the bylaws that required contributions of record for over a 6-month period in order to vote. According to appellees, all they required was that someone come and give $1 to the church, and they allowed them to vote. They essentially stuffing the ballot box, if I can use that phrase.
The
By
trial court didn't
adding members who
Counsel,
had not
yeah.
qualified under the bylaws.
The trial court, I don't recall the trial court drilling into that exact topic. Was that a point that was made to the trial court, or is that a thought that has occurred since the trial court's ruling? I just don't remember the trial court addressing that concern.
The trial court did not address that. We did raise the issue of the validity of the 2016 election. We did not make that specific point. I would note that the Supreme Court has indicated that, and pardon me while I grab my glasses so I can actually see. In LeBron versus National Railroad Passenger Corp., the Supreme Court held that if a claim is properly before the court, then it may consider any new arguments or theories underlying that claim. So I acknowledge that matter, while it was before the trial court and the evidence was before the trial court, this wasn't something that we emphasized in our briefings to the trial court.
I mean, my impression.
Nonetheless, it bears on the claim.
My impression is that the trial court felt that this carefully monitored October 2016 election with the former judge of this court supervising this was really done according to Hoyle. And I don't think anybody made any sort of argument that at the time it was before the court that people who shouldn't have been allowed to vote were allowed to vote. I understand your point that there's a line in Appellee's brief in this court that can be interpreted as raising a question about that, but I don't know whether that may be fodder for another lawsuit, God forbid. I suppose.
Well, in my view, Your Honor, it is just another reason why this proceeding needs to be remanded, why the record needs to be refreshed, so that these issues can be adequately addressed. I see that I'm losing my time here, but I will note that we've given a number of reasons why the trial court's decision with respect to the 2014 and 2015 elections was contrary to the evidence and contrary to the law. I'm happy to discuss those in more detail if you wish, but I do think we adequately addressed it in the brief.
Well, let us hear from counsel for appellees, and we'll give you a few minutes in rebuttal. We may have more questions for you then.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. My name is Don Thompson on behalf of appellees, along with my co-counsel, Michael Giuffre. We asked this court to affirm the trial court's decision for 3 reasons. First, appellant has not satisfied their burden of showing standing, as they have not shown there were 0 vacancies at the time of the October 2016 election. Second, the trial court's holding was grounded in fact, correct, and not clearly erroneous. And lastly, even if appellant were to succeed on both of those points, this entire case is moot in light of the intervening elections since that have occurred. This court's 2018 remand opinion.
Can I ask you a question about the mootness? I've been wondering about this mootness argument, which I've had a little difficulty understanding on the existing record. We don't know anything about the intervening elections, do we? You may know about them, but
Your Honor, we know that there's elections every 2 years. Both boards have said they've continued to hold elections. And the October 2016 election itself is an intervening election that moots this case.
But why is it mooted? I mean, if the January 2017 board decision to dismiss this lawsuit was a valid decision, then the lawsuit is dismissed. If it was not a valid decision, then the lawsuit is continuing. Why is it that subsequent boards, we haven't been told subsequent boards have ratified or that the parties have come to any sort of agreement or anything of the sort? Why does that moot things?
Yes, Your Honor. So you're absolutely correct. If the January 2017 election is valid, then the case is dismissed and we don't need to get to mootness, which is why the trial court never explicitly ruled on whether there is a mootness issue. To get to mootness, appellant would have to show 1, the 2015 vote to initiate the lawsuit was correct and that they had proper standing to bring the lawsuit in the first place. 2, they have to show that the October or January 2017 vote was incorrect and that the board members who voted in January 2017 did not have standing. And then if they can make both of those, it would still be moot because the elections have been since then. The reason it's moot is because the only
You skipped
relief-
over the March 2016 board meeting.
We do have.
Is that not relevant to us?
In the motion to dismiss briefing before the prior appeal, appellant had filed the meeting minutes from the March 2016 election, as well as I believe another election after that. That's the only evidence that they've put forward. We would argue that that is not meeting the burden of proof that the March 2016 is valid.
Well, let's talk for a moment about why not. Those meeting minutes, the March 2016. I don't know if they're actually minutes, but they're a memorandum of what happened. Say that something like 190 plus members voted for voted in the board election, and at which some, not all, but some of the appellants were elected. Explain why that does not meet the burden of standing.
Yes, Your Honor. So
for those board members, put aside the argument that the meeting was not held in October, which frankly is not that persuasive an argument, unless you really want to push on that. What's the problem with that
Sure.
March 2016 election in your view?
Well, Your Honor, the problem with the March 2016 election is it didn't have quorum under the 1996 bylaws. There's never been any showing that they attempted to comply with.
How do we know that?
In the October 2016 election, and Judge Von Kahn's very meticulous recounting, he indicated there were, I believe, about 800 church members. So 190 would fall far short of quorum. At this point in time, the churches had split off into 2 factions. They were meeting at a different church. Their 200 was separate from that 800. All of their members were invited into the October 2016 election. If they wanted to vote, if they wanted to run, they were permitted to run. They did not. There's no indication in the record that they invited the other members from the other church or considered them in any way in their membership counting.
Where the record is silent on various aspects of this case, who does that cut against?
The appellant, Your Honor, it is their burden to prove standing, which they have not done. And on remand, this court tasked the trial court with 3 very specific questions to supplement the record to explain why there was reasons to believe the 2014 and 2015 elections were invalid. The trial court fully addressed those issues, cited the reason.
You say the trial court fully addressed them, but focused on, I guess, the first of those reasons, which was about payment of financial contributions or tithes or dues, different formulations at different times. Your opponents say that the trial court didn't really fully address that topic, that the trial court's ruling refers to one piece of evidence on the topic and doesn't address other evidence, for example, testimony that they rely on, which they characterize as being testimony from folks who've been members of the church for a long time, that said even under the 1996 bylaws, there was a requirement of monthly contributions, and if you didn't contribute, you weren't allowed to vote. What's your response to their critique that, contrary to what you just said, the trial court didn't really fully analyze that issue?
Yes, Your Honor. First of all, the $20 is only one small aspect. The overall holding is that there were different membership requirements, eligibility, voting in the totality. $20 is absolutely one of those issues. And in the 1996 bylaws, there was no set dollar amount that would have met the burden. Their own witness, Dr. Metafaria, testified that $1 would have been enough and that he didn't know the intent of the authors of that election. Well, we do know the intent of the authors of the election because in Judge Von Kahn's recounting, his task was to draft procedures that were in compliance with the 1996 bylaws. In doing that, he analyzed the court's opinion, he analyzed the bylaws, he met personally with the founder of the church and several leaders of the church to get their views on what was meant by those bylaws. And he consulted with counsel for both sides, including counsel for appellant, who was invited to comment on whether the procedures were valid in accordance with the 1996 bylaws or not.
Well, that's a lot of information, none of which is in the trial court's full, according to you, full explanation of this issue. But I'm not quite, is the logic of it that whatever, even if one were to credit testimony, that as a practical matter, what was happening under the 1996 bylaws was that they were demanding, pay monthly contributions or you don't get to vote. That it sounds like your train of thinking seems to be maybe, well, if that was happening, it shouldn't have been when Judge Von Kahn did this the right way in 2016. Something different happened. I'm not, what's the logical relevant, how does that fit into this topic?
Your Honor, it fits into the topic because it depends on what the actual requirement was to satisfy voting eligibility. In the 1996 bylaws, it said to vote, you need to be a member. To be a member, you need to make financial contributions of record. And if you were a member, you're entitled to vote. There was no suspension provision. That was one of the new 2012 bylaw provisions. There was no $20 requirement. And there's ample testimony in the record that from election to election, month to month, and of course of 8 months, the membership went down 100 and then back up 100 because of that new suspension feature, because of the new payment of dues of $20 a month. And notoriously, the leadership under appellant had difficulty meeting quorum at any votes. They didn't hold an election in 2011. They didn't hold one in 2012. They didn't hold one in 2013, partly because of the quorum issue. They couldn't pass the 2012 ballots because of the quorum issue. In 2014, they tried to hold an election, couldn't, had to schedule another meeting because of quorum issues until they finally got it. And now miraculously in 2015, they say there was a typo, but quorum was there, but they didn't have a single witness in the record testify that they personally were involved in verifying quorum. What we have in the record instead is the secretary of the elections committee, Priest SALAM, resigned because he wasn't even allowed to see the membership list. He couldn't do his duties. 3 weeks before the election, the secretary of the election committee didn't even know how many members were in the church.
One thing that puzzled me about this case, if I could just interrupt you, people talk about members of record. Did anybody bother to produce the records of members? I mean, you would think that what one would do is say, well, we have records. We have for each person who claims to be a member, we have, documents showing that when they paid and whatever. And, the names of who's a member and so on and so forth. But none of that is produced.
Your Honor, it was produced in regard to some meetings, but not others. According to the testimony, the chairman of the election committee is the one that would have the ballots and keep control of that. When our appellees regained control of the church, the door to the office was locked. When they got in there, records were missing. The other side has also said they don't have the records and don't know where it is. So there should be records, but neither side seems to know. With regard to other meetings, there have been membership lists that would have been submitted showing there were over 500 members. For instance, in November 2015, there were actual ballots submitted in the underlying trial court record relating to those votes. So those were well documented. But with regard to this 2015 election, the minutes don't even say how many members are there. It just says quorum was met. The first minutes didn't even specify specifically how many were there. Dr. Metafaria himself, who was on the board, said, I don't know how many members were there. I just know it's more than 130, which is what the top vote getter got. He said, that's not my job. That's the chairman of the election committee. And we have no testimony in the record from the chairman of the election committee.
With regard to the October 2016 election, where you mentioned that Judge Van Kahn noted a total of 800 members. What's the basis for that determination?
Your Honor, he spells it out in about 2 to 3 pages in the record around Joint Appendix 80. And under that, they verified the membership booklets. Each member of the church has a booklet. It's got the church's name on it. It has every contribution they've ever made, whether it's dues, building fund. And the church, according to Dr. Metafaria, keeps records of every single dollar that anyone spent for any purpose. So these membership booklets are supposed to represent that. To verify, the church checked their internal records and they asked for the membership booklets of people showing up at the meeting. There was one case where someone had a membership booklet from the faction church at this point. They had a slightly different booklet. They didn't have any contributions to the primary church. They were offered the option under this 1996 bylaws procedures to contribute $1 and they would have been allowed to vote if they wanted to. They declined that option. There was no one in the election who voted based on just $1. So we gave that option. It was never exercised. It's immaterial, but it was there because under the 1996 bylaws, according to the founder of the church, the judge who analyzed all the evidence and comments submitted by interested parties, that was sufficient under the 1996 bylaws as written. And this court held that regardless of what happened in 2015, in the 2018 remand opinion, they said the controlling bylaws require an election in October 2016. So the issue is not what happened in 2015. The issue is how many vacancies, if any, were available in October 2016. So whether or not Dr. Amari Kasai was the ELECA, that's not enough to remand it. They have to win on everything. They have to prove March 2016 was valid, so there's no vacancies there. March 2015 was valid, so there's no vacancies
By the
there.
way, something that occurred to me when you said, suppose there were no vacancies in October 16. I may be missing something obvious, but why is it that the fact that there are no vacancies prevents the General Assembly from nonetheless saying, well, let's still have a meeting. We don't like these people. So who are in there now, and let's just have an election for new people. Why is it that there have to be vacancies for that election to be valid?
Your Honor, we would submit there is no requirement, and we were.
Nobody's made this argument, so I
So in
suspect there's something wrong with it,
2015,
but I'm not sure I know why exactly.
the argument was made in 2015 initially, and Your Honor's asked some questions about this earlier. The 2015 vote, we have record findings by Judge Ross that no notice was given to the permanent members. So this initial vote to file the lawsuit, they didn't give a notice. So the argument now is that in 2017, Amari Kasai did not have notice. That would invalidate the election or even bring this suit in the first place. But in 2015, that's precisely what happened. Over 500 members of the church got together. They signed a petition. They said, we want these people out. They're not following the bylaws. They're violating our procedures. They've been in power longer than their terms permit. They haven't held elections for 3 years. the secretary of the elections committee resigned because he wasn't able to do his job. And the 80-page transcript, he said repeatedly, the elections were illegal, they didn't follow any of the procedures, and that's why I resigned. He didn't say that I don't know if quorum was present because he had no ability to know. That's the entire reason he resigned, is because the chairman of the election committee refused to give him the member list. So no one knew whether quorum was present or not, except for maybe the chairman of the election committee. But we haven't heard any testimony from him.
Can I ask you another question about the quorum? The trial court, in determining that your opponent had failed to carry the burden of showing that there was a quorum, gave 3 reasons focused on the quorum. And your opponent makes a variety of arguments about various of them, but one of them, focused on the second of them, is that that's just factually incorrect. That what the trial court said was that there were minutes from a meeting on March 7th that showed membership of 564 members. And your opponent says that's just not a correct description of the relevant evidence. Do you agree that that's incorrect? And if you do, why do you think that's not load bearing?
Yes, Your Honor. So we agree that the March 7th document that is being cited by the court, they were not minutes, they were a letter from the secretary of the elections committee laying out grievances, laying out that he was told there's 564 members of the church by the chairman, but he was not given proof to verify independently. He was also told 600 ballots were getting sent out. This is in his transcript testimony. So he is confused because he's being told there's 564 members, no way to verify it, and he's being told 600 ballots are going to go out to nominate, even though only members should be able to nominate. So he resigned. He aired his grievances at the meeting, and he tried to do something about it, but was unsuccessful. And
so I took you to answer half of my question, which was
yes, Your Honor,
that it's inaccurate, that those are not minutes from a meeting on that date. Maybe the rest of your answer was an implicit response to the second half of my question, which was compound, I acknowledge, which was, if that's a mistake, why is it not load bearing? Why shouldn't we say, well, the trial court made a finding of fact, but the finding of fact rested in part on a mistake about what the facts were. And so we need the trial court to think again, understanding the facts accurately.
Yes, Your Honor. I believe it would be immaterial and not meeting the standard that would justify remanding this opinion and putting both parties through additional years of the litigation that's been going on for 7 years across at least 3 or 4 courts and as many appeals. It's equivalent to a typo. There's no indication in the record that his determination was on the fact that it was minutes versus a letter. His determination was that the document said there was 564 members at the time. That was the relevant piece the judge relied on, and there's been no dispute.
Well, just the document itself, I mean, it's not the only mistake in the sentence isn't only that it was whether it was minutes from a meeting on a date. I think maybe all 3 of those things being incorrect. But it also uses the word showed that the church had a certain number of members. And I thought the document instead was a letter saying someone had told the letter writer that, which is, I think, a fair bit removed from showing anything.
Yes, Your Honor. And my response to that would be it's appellant's burden, and they were on notice and aware of this issue. Specifically in Dr. Metafaria's deposition, he was questioned on this, and he said, was presented the document. Do you have any reason to dispute there's 564 members at the time? No, I do not. He had absolutely no reason to dispute it and said, I don't micromanage. I'm not involved in this. So based on that, not only is it their burden, but they were on notice and specifically questioned about it, and they did not produce any evidence to refute that at that time there was 564 members.
And that, I mean, explicitly, that is probably more an argument about why, notwithstanding any mistake there, your opponent didn't actually carry its burden of proof in your view. It's a little less direct about why we don't need a remand. I mean, again, is your point that the evidence, it was just so clear based on the other 2 points the trial court made, and also all of the other evidence that you've referred to that the trial court didn't explicitly refer to, that sending it back would be pointless, because both the trial court obviously would reach the same conclusion and any reasonable fact finder would have to? Or is that a fair characterization of your points, sir?
That is correct. I don't believe it's prejudicial or material, and that the trial court has on at least 4 occasions considered all of the facts and continually rejected. The specific issue about the minutes versus letter was addressed in the trial court briefings The judge said he reviewed the entire record. It was before the judge, and he specifically did not change his opinion based on those arguments. Here, it's on the totality. The only way that the March 2014 and March 2015 elections, July 2014 and March 2015 are valid is if the 1996 bylaws and the 2012 are equivalent in every single respect, such that they accidentally complied with the 1996 bylaws, even though they were intentionally following the 2012. There are numerous differences between the two bylaws that clearly affected the validity of the votes and the membership counts. We talked about the membership dues and the new suspension feature that was not present in the previous bylaws, but there was also a feature that made it so families get one vote unless they specifically apply for more, whereas in the previously, each person can be a member within a family.
That wasn't, again, anything the trial court ruled on, though. Is that correct? So it's a little unclear how we should factor it into our thinking about the correctness of the trial court's ruling.
Yes, Your Honor. So we did raise it in the trial court briefing, and the trial court did say they reviewed the entire record, but that is absolutely correct. They did not explicitly cite that as one of the factors. But I would posit there's no burden on the trial court to list every factor under the sun in this thousands of pages of record as to why these two elections were invalid, when there are numerous, very substantial and material reasons why they're invalid. So every single reason doesn't matter if the other reasons cannot be overcome. And those reasons are very substantial, both from the membership, just by their own testimony, would vary by 100 because of these new requirements. The wrong month, which I do disagree a little bit with opposing counsel in that the DC code has a provision in the exact same section that says the annual meetings must be held at a time stated in the bylaws. There's another provision that says you can only elect at an annual meeting. The reason behind the provision saying the election is not invalidated if it's not at the time stated in the bylaws isn't because you can in perpetuity violate your own bylaws. It's because things happen. Sometimes you need to do an emergency meeting. You need to do a special meeting. And that's what the DC code says. It says it must be at an annual meeting for the elections unless another provision in the bylaws holds for another procedure. And that's what these bylaws do. There's an emergency.
The unless part is not part of the statute. That's your interpretation of the statute. You're not
No,
purporting to
that's
say that
in
the statute has
the
language.
statute as well. I can cite it if you look. That one wasn't in the briefing. But it is 29-406-04. The directors of membership corporation, other than the initial directors, shall be elected at the first annual meeting, the members, and at each annual meeting thereafter, unless the articles or bylaws provide some other time or method of election, or provide that some or all of the directors are appointed by some other person or designated in some other manner. So this is very consistent with the DC code. Is absolutely, it's not invalid because it was in the wrong month. If it was in the wrong month because of another procedure. And in the record, they've followed that other procedure before for some of the elections. The meeting minutes say.
I have to say, I don't follow what you just said. The provision which says failure to hold a meeting in the correct month doesn't affect the validity of a corporate action. Says the failure to hold an annual or regular meeting at the time stated in or fixed in accordance with the articles of incorporation or bylaws. So if to the extent your point is this provision only protects meetings that are held in the wrong month, if there's a bylaw that says you can hold them in that month, it seems circular because then it's not the wrong month. So I'm not quite sure what you think the function of this provision is.
Your Honor, I think the function is a gap filler, because otherwise, if it was not in the time stated in the bylaws according to the provision to numerates above, then it would be invalid. If you couldn't get quorum at the meeting, like in January or July of 2014, and you had to have another meeting 2 weeks later, and you did get quorum, under the DC code, without that provision, that would be an invalid election because it was not a time stated in the bylaws. This kicks in as a gap filler to say it's not invalidated, but if there is another provision in the bylaws providing other procedures, then those must be followed. So here, there are other provisions that must be followed, but if there were not other provisions.
I'm sorry, and you think there are provisions that relate to the holding of an annual, there are other provisions in the bylaws about what to do with an annual, when to hold an annual meeting if you don't hold it at the right time?
There are other provisions in the bylaws about the different types of meetings, and we have testimony from multiple witnesses that The annual meeting, Dr. Metafaria testified, was the meeting that occurs according to the timetable stated in the bylaws, is what he testified to in his deposition. He and multiple witnesses said, other than the annual meeting, you also have two other options. The board can call an emergency meeting, or a certain amount of the membership can petition to force the board to hold a meeting. But no witnesses testified that there were other procedures outside of those three options. And appellant's counsel in 2015 even argued.
To make sure I understand your understanding of this provision, imagine that what had happened here under the bylaws that we're working with here had been that there was an effort to hold the annual meeting in October as required by the bylaws, and they had fallen short of a quorum and they rescheduled it for 2 weeks later. Do you think this provision would protect the validity of that? Or do you think instead, under your analysis, there are other provisions about other meetings and there's testimony about other meetings, and that wouldn't be the right kind of meeting, and therefore it would be an emergency meeting, and therefore it would be valid only if the requirements relating to emergency meetings were met?
I believe that it would protect that meeting because of that provision, and because, as my recollection, there's another provision in the bylaws that if you fail to meet quorum, you may hold further meetings, and if you still can't achieve quorum, essentially the quorum is waived, so you can still do some business. I believe that applies to annual meetings. With regard to amendment passages, there's a separate that essentially that doesn't kick in, and I'd be happy to submit supplemental briefing on that issue if desired. I don't want to misrepresent, but that is my recollection of what at least one of the versions of the bylaws. I think it was the 96, but I'd be happy to submit supplemental.
I mean, your interpretation of the statute seems somehow, it does feel a little strange. Suppose you had a very simple articles of incorporation or bylaws, which simply say there shall be an annual meeting at which directors are elected and so forth every 2 years in October. And that's all it says. It doesn't have any provisions about emergency meetings or alternatives or what have you. And suppose the people who are running the corporation or just overlook that requirement of October, and they hold a meeting either in September or November, whatever, or any other month, I don't care. It seems like just reading the statute on its face, or they fail to hold a meeting. It seems like reading the statute on its face, the last sentence of the statute says it doesn't matter. It doesn't affect the validity of any corporate action. And it's hard to read it as not saying that. And if that's true, the fact that, you know, all right, the bylaws here were a little more complicated. It's hard to see why that would make a difference.
Yes, Your Honor, and I would respond to that most of these provisions are gap fillers and models to abide by. There are other provisions in the DC code that has the emergency meeting and special meeting provisions, which are largely what the bylaws appear to be modeled after. So because those additional gap fillers are there, that would also solve that issue of how you would present these other meetings. But one of my primary key points that I'd like to get to, because I see my time is low.
I'm going to prolong this a little bit because I want to get back to the question of mootness, which I want to be sure we've examined that carefully. Your point on mootness is that a few years have gone by since that January 2017 decision. And in that interim period, there have been other board meetings of this church, which have not been, so far as I know, have not been challenged. There's been no litigation about them. There's been no, now what's the next step in the argument as to why this fact renders this litigation moot?
Yes, Your Honor. So the reason why it renders it moot is because there is no request here for monetary relief or any other relief this court could effectively fashion. The request here is for declaratory judgment that the 2015 board is the proper board, presumably today, and that the removal was improper. This is a purely academic question, and this court is held in regard to elections that subsequent elections moot. It's similar to the Thorne case cited in the briefing, that a subsequent sale of a property moots an issue about the contracts. Once it's gone beyond recall, you may have other remedies, but if you're looking for a declaratory judgment you can't reverse everything that's been undone. You can't invalidate every action that has happened since 2015 and put a 2015 board back in power. The reason it's moot is because it's seeking declaratory relief here that is no longer a live controversy.
Why is there, the Eagle Bank was a party to this. They apparently must have put something in escrow, or how does that affect the question of mootness that you're raising?
Your Honor, that doesn't impact the question of mootness. The reason Eagle Bank is involved in this is because at the time of this initial lawsuit in 2015, the church was about to break ground on a new church. They had been raising money for years and years, received millions of dollars in donations, and that funds have been frozen since 2015. The church hasn't been able to build their new church. They haven't been able to put that money to good use to the community. They just have the money frozen in Eagle Bank's bank. So they're a party because once a final judgment comes in this matter, the church will be able to use those funds again.
The former I don't know what to call them, the non-dissidents, the former church board and their supporters formed a new church.
Yes, Your Honor. It's my understanding that they formed a new church that they've been going to for a while, and according to public records, they've also purchased a new property and they're seeking to build a new church, is my understanding. And I'm happy to be corrected if I'm wrong.
But this litigation doesn't involve a fight between that church and this church over the property that's in the bank account or anything else.
Not directly, Your Honor. Presumably, if they were to get declaratory judgment that the 2015 board is still the board to this very day, then they would have control of those bank accounts. They would be able to dispose of those assets and do with what they will, as long as it's in accordance with.
So is that if that's true, is that an acknowledgement that the case is not moot?
No, Your Honor, that was never brought as a claim in this case. They've never amended the complaint, and we're not seeking monetary damages. They're seeking declaratory judgment that is absolutely moot because it is an academic question, and vindication is not enough. Personal reputation harm is not enough, as this court has held multiple times. So the academic question of whether 2015 was wrong is why it's moot. And this court also, in the 2018 remand opinion, held and rejected the fruit of the poisonous tree that any misconduct in 2015 should affect the future. This court said, no, regardless of what happened then, you have to hold an election in October 2016. If there's seats, then those people, it's a valid election.
So just to again press you, because I want to understand this mootness argument. So who's the alika? If we think of this as moot, who is now the church administrator?
Yes, Your Honor, and I thank you for asking that question, because I was meant to circle back on the earlier question you had. Judge Mott, in his 2020 opinion, right before the conclusion on page 44 of the record, I believe explicitly said that Mr. HABTE was appointed after that October 2016 vote, before the January 2017.
I know he said that. I've been wondering what the basis for that statement is, what the evidentiary basis is.
Off the top of my head, Your Honor, I'm not sure. It could have been testimony. It could be in the lower court's record. Most of the record relating to the intervening events was in the initial amended motion to dismiss briefing before this appeal in 2018. Even though the majority of the issues presented in this appeal are the copy and pasted issues from 2018, that was in the record then. That was the last time anyone has ever introduced evidence relating to it. And since then, there's been no evidence argued, no change of law, and no clearly erroneous factual findings have been shown. So they had the opportunity to brief it at the trial court in response to the motion to dismiss. They submitted a couple of affidavits. That was it. But they were on notice, and it was absolutely part of the lower court's briefing before the previous appeal.
Okay.
If there are no other questions, Your Honor, I thank you for your time.
Thank you. Mr. Lyon?
Council made a number of representations concerning what the record is. I would submit to you that a great many of them are simply not the case, not supported in the record. With respect to the last question raised regarding the ALICA, Judge Mott provided no citation to support the conclusion that Mr. HABTE is the ALICA, and there's absolutely nothing in the record that does support it. Question was raised as to the original vote to bring this case. There's been no determination that the original vote to bring this case was invalid. The representation was made that appellants were invited to comment upon the procedures for the October 2016 election. I will make the representation that I received a call from Judge Van Kam asking me to do so and giving me less than 24 hours to do so, which was impossible in light of the need to consult with my clients. I asked for additional time and that was denied. With respect to the suggestion that there were a multitude of inconsistencies between the 2012 and 1996 procedures for the election. The only one that was cited and relied upon by the trial court was this question of the payment of dues. So we don't know what the trial judge considered to be inconsistent other than this question, and we submit that the judge was incorrect in his determination with respect to that matter for the reasons we cited in our brief, that basically it is irrational to think that one must pay tithes to be a member of the church, but you can be dismissed from the church for not paying dues, and that there's some other payment of $1 in order to vote. The bylaws say contributions of record for the 6 months preceding the election. That plainly indicates an intent for consistent contributions to the church, i.e. dues. And the testimony, the only testimony with respect to this matter was that the church had required payment of dues of $20 a month for more than 20 years. That was Mr. Bacali, and Ms. Sion testified to that as well. The question arose as to testimony considering the presence of a quorum. Ms. Sayum, whose department was responsible for determining whether a quorum was present, testified that a quorum was present. Mr. Bacali, who participated in the counting of the members, testified that a quorum was present, yet the court failed to address that testimony. Now, the requirement is of a reasoned decision, and the court is required to address conflicting evidence and to resolve that. The court possibly could have determined that this testimony was not credible, but the court didn't. The court simply ignored that and relied upon what we consider to be speculation and erroneous determinations to determine that a quorum was not present. The question arose as to the lack of records. Well, the church's office had been padlocked, and the ALICA could not gain access. We could not gain access The judge, while this is not on the record, I made a request to the court to allow us to inspect the records and gain entrance to the church's office. That was denied. Again, it was not denied on the record. My mistake in not having that put on the record. But I want to make that clear.
I would have thought there'd be a motion to compel discovery if you needed to. I would have thought there'd be a motion to compel discovery if you needed to get to that point.
Again, my mistake, Your Honor. I should have done that. And finally, if I didn't point out before, the only reliance by the judge to determine that the election was contrary to the bylaws was this dues issue. There were no other matters cited. They've raised it in their briefing, but if it's not relied upon the judge, I don't think that you can rely upon it in order to uphold the decision.
Could I ask you to speak to the question of mootness that your adversary has raised?
I meant to get to that and I ran out of space on my paper. I'm sorry. Council mischaracterizes the relief that we requested in the complaint. Among the relief that we requested was to reinstate the proper board and to enjoin the appellees from prohibiting members who were loyal to the board and to the ELICA from enjoining them from preventing them to enter the church. So certainly that relief is outstanding. There's never been a determination on a request for a permanent injunction here. So it's just not a request for a declaratory judgment. And again, the issues regarding the 2017 board vote to dismiss this case is certainly extant, given that members from the 2015 election and Dr. Amare Kase were excluded from any such board vote.
Well, let's see. To the extent you're requesting reinstatement of the proper board, that does sound like it might be moot because their terms would have long since expired anyway.
Well,
Since then, is that right?
At this point, well, I have two responses to that. First, at this point, we don't know the validity of any elections that have occurred since 2016. And to the extent that they may be and probably likely are invalid under DC law, until a successor is validly elected, the preceding board remains in effect. I cited that. I don't have that code provision in my head, but I did cite it in the reply brief. So to the extent
Well, I would have
that
thought
all
that
the
I would have
elections
thought
have
that
been
when new
invalid,
elections are
the-
not
the-
challenged.
I'm sorry.
I would have thought, I think, that where new elections are not challenged, they're presumptively valid. In other words, if we hear, well, all this is ancient history because in 2021, whatever, there was a there was an election, nobody's challenged it, and we have a new board. I would have thought that in the absence of a challenge.
Oh, Your Honor, I haven't had an
know
opportunity to challenge it. I'm perfectly willing to amend my complaint to do so.
Yeah.
And upon remand, I will definitely do that. But at this point, I haven't had the opportunity to submit or to move to amend my complaint.
Okay,
Thank you, Your Honor.
counsel, thank you both. Case is submitted.
Your Honor, may I have an opportunity to respond to the very last point or request supplemental very briefly?
I think probably the best course would be for you to request supplemental briefing, file a request, and the opposing counsel will have an opportunity to address that.
Thank you, Your Honor.
All right. This honorable court is now adjourned.